I built Ashcroft millwork with my own two hands starting in a rented pole barn outside Lancaster, Pennsylvania, back when Reagan was still in his first term. 39 years later, I found out my son-in-law had spent the last 18 months quietly maneuvering to take it away from me, using my own daughter's signature to do it. I want to tell you exactly how that happened, and exactly what I did about it, because it's the kind of story that starts small and ends with a man learning what his family is actually made of. My name is Harold Ashcroft. I'm 68 years old. I make custom architectural millwork, staircases, mantels, built-in cabinetry, the kind of work that ends up in the historic homes around Lancaster County and increasingly in high-end builds down toward Philadelphia. I started that business with a used table saw and a bank loan my own father co-signed, back when I had more ambition than sense. 39 years later, Ashcroft Millwork employs 22 people, and the building I once rented, I own outright, 4 acres and 60,000 square feet of shop space off Route 30. I have one child. Rebecca, 34. She's the reason I get up some mornings, if I'm honest with you. Her mother, Diane, passed of a stroke 9 years ago, sudden, no warning, dawn before the ambulance made it to the house, and after that it was just Rebecca and me for a long while, until she met Trent. Trent Callahan came into our lives about 6 years ago. Smart, polished, the kind of young man who shakes your hand a beat too firm and holds eye contact a beat too long, like he learned it from a seminar. He worked in commercial finance downtown, moved into a director role at a regional bank about 3 years back, and I want to be fair to him in this telling, the way I try to be fair to everyone in these stories. He was good to Rebecca. He showed up. He remembered birthdays. For a long time, I had no real complaint against the man, beyond a low, quiet feeling I could never quite name, the kind of feeling you get walking past a floor joist that looks fine but doesn't sound right when you knock on it. Welcome to Dad's Raw Revenge. Get comfortable, and remember, the people in these stories had every chance to behave themselves. They just chose wrong. Drop a comment, hit that like button, and make sure you're subscribed. Trust me, you're going to love it here. Let me take you back to how this actually started, because it didn't begin with a lie. It began with something that looked, on the surface, like generosity. About 2 years ago, Trent started coming around the shop more. Not to work, that was never his world, but to talk business. He had a way of asking questions that felt like genuine interest at first. How was the succession plan looking? Had I thought about what happens to the company if something happened to me suddenly, the way it had happened to Diane? Was I protected against liability the right way, given how litigious construction contracts had gotten in the last decade? I'll admit, I liked the attention. At 66 years old, running a business alone, most days nobody asks you those questions except your accountant, and your accountant charges you for the privilege. Here was my son-in-law, a man who understood finance for a living, taking a real interest in the thing I'd spent my whole life building. I let my guard down. That's the plain truth of it. I let my guard down because it felt good to be asked. About 14 months ago, Trent sat me down at Rebecca's kitchen table with a folder of paperwork and a phrase that, looking back now, should have set off every alarm I had. "Harold," he said, "I want to help you protect this business the smart way, for Rebecca's sake, and for tax purposes down the road." The plan, as he explained it, was straightforward enough on the surface. I would restructure Ashcroft Millwork into a holding company, with a new operating entity underneath it, the kind of structure his bank's commercial clients used all the time, he said, to shield personal assets from business liability and to set up a cleaner path for eventual succession. Rebecca would be named as a co-managing member of the holding company, 50%, right alongside me, which made sense to me at the time. She was my only child. Of course she'd inherit the business someday. Why not formalize it now, while I could still guide the transition myself, rather than leaving her to untangle it after I was gone the way I'd had to untangle things after my own father passed? I brought the paperwork to my accountant, a woman named Sandra Voss who'd handled my books for 11 years and who I trusted the way you trust somebody who's never once given you a reason not to. Sandra looked it over and told me it looked reasonable on its face, standard restructuring language, though she recommended I have a business attorney review the operating agreement specifically before I signed anything, since restructuring documents can bury important details and definitions sections nobody reads closely. I want to tell you I did that. I didn't. That's on me, and I'm not going to pretend otherwise in the telling of this. I was 66 years old, tired in a way that had nothing to do with sleep, and I trusted my son-in-law, a man who did this kind of thing for a living, more than I trusted my own instinct to slow down. I signed the holding company documents on a Tuesday afternoon in my own kitchen, with Rebecca sitting right there, smiling, telling me how relieved she was that we were finally getting things organized the right way. If you've been listening for a while, do us one quick favor. Subscribe. It costs you nothing and it means everything to us. Hit the like button while you're at it and drop your thoughts in the comments. For the better part of a year, nothing seemed different. I still ran the shop the way I always had, still walked the floor every morning at 6:30, still signed off on every major purchase order myself. Rebecca's name was on paperwork somewhere in a filing cabinet, but it didn't change my daily life in any way I could feel. That's exactly how something like this is designed to work, I'd learn later. Slow enough that you never feel the ground actually shifting under you. The first real crack came about 4 months ago, in a way so small I almost didn't notice it. I went to approve a routine equipment financing application, a new CNC router I'd been wanting to add to the shop floor for 2 years, a piece of machinery running close to $200,000. My longtime loan officer at the bank, a man named Curtis Bell who'd financed 3 separate equipment purchases for me over the years, called me directly instead of just processing the paperwork the way he normally would. "Harold," he said, "I need to ask you something, and I hope it's not out of line. The application's coming through fine on the financials, but the authorized signer field on the holding company documents lists Trent Callahan as a secondary managing member with independent signing authority above a certain dollar threshold. I just want to confirm that's something you're aware of and comfortable with, because that's not standard for a family succession structure I've seen you use before." I sat in my truck in the shop parking lot for a long moment after that call, the same way I'd sit with a piece of lumber that looked fine from one angle but showed a hairline crack the moment you turned it in the light. I told Curtis I'd get back to him, and I drove straight to my attorney's office that same afternoon, a man named Elliot Marsh who I'd used for contract disputes over the years but never for anything involving my own family. Elliot pulled the full operating agreement, the entire document, not just the summary pages Trent had walked me through at that kitchen table 14 months earlier, and he read through it slowly while I sat across from him trying not to say anything that might interrupt his focus. "Harold," he finally said, setting the document down and taking his glasses off, "I want to walk you through exactly what you signed, because I don't think it's what you believe you signed. Here's what I understand now, the plain version of what was buried inside pages of definitions and cross-referenced clauses I never had reviewed independently. The holding company structure wasn't simply a 50-50 arrangement between Rebecca and me. Buried in a section labeled Management Authority and Contingent Succession Provisions, there was language granting Trent, as Rebecca's spouse and a listed advisory member, independent signing authority on any transaction under $500,000, without requiring my sign-off, the moment a specific trigger condition was met. That trigger condition was defined, in dry legal language that took Elliot a full read-through to untangle, as any period during which I was deemed, by a licensed physician, to have a diminished capacity to manage day-to-day operations, whether temporary or permanent, as certified by a single physician of the managing member's choosing. A single physician. Chosen by the managing members. Which, under this document, meant Rebecca and Trent together. I asked Elliot, plainly, what that meant in practice. "It means, Harold, if you have so much as a bad reaction to anesthesia during a routine procedure, or a stretch of pneumonia that lands you in the hospital for 2 weeks, and Trent brings in a physician of his choosing to sign a diminished capacity form, he gains independent operating authority over transactions up to $500,000 without needing your signature at all. And there's a secondary clause here, further down, that allows the holding company's managing members to vote to convert that authority from temporary to permanent if the diminished capacity condition persists past 90 days, based on the same physician's ongoing assessment. I sat there in that office chair for a long time, the same stillness I imagine settles over a man right before something in him decides to change permanently. "He built himself a door," I said, finally. "A door that only opens if I get sick or old enough that I can't watch it happening." "That's precisely what he built, Harold," Elliot said. "And I want to be direct with you. This kind of clause isn't accidental. Nobody drafts contingent capacity triggers with independent signing thresholds by accident. Someone who understands commercial banking structures wrote this, or had it written, very deliberately." I drove home that evening past the shop, past the building I'd spent 39 years building brick by brick, and I sat in my truck in my own driveway for the better part of an hour before I went inside, doing the same kind of methodical thinking I used to do, laying out a difficult staircase design, working backward from where I needed to end up to figure out every step that had to come before it. I want you to understand something about me before I tell you what I did next. I am not a man who explodes. I've never once in my life slammed a door or raised my voice in a business negotiation, and I wasn't about to start now, sitting on the single most important piece of information I'd uncovered about my own family in years. Rage, I've learned, makes you sloppy. And I needed to be anything but sloppy. I want to tell you about my relationship with Rebecca honestly, the way I try to tell every part of this honestly, because I don't believe she orchestrated any of this. I believe, and I still believe now, that my daughter signed those documents the same way I did, trusting a smart husband who explained complicated financial language to her in a kitchen and made it sound like protection instead of what it actually was. I don't believe Rebecca understood what that diminished capacity clause meant any more than I did when I signed it. That distinction matters enormously to how I chose to handle what came next. If you have been listening for a while, drop your thoughts in the comments. Hit the like button while you're at it, and be sure you're subscribed. I spent the next 3 weeks doing exactly what Elliot recommended, quietly building a complete picture before I moved a single piece. I asked Sandra, my accountant, to pull every transaction that had gone through the holding company structure since it was formed, looking specifically for anything that had used Trent's advisory signing authority, even below the $500,000 threshold, just to understand the full pattern of what he'd been doing in the background. What Sandra found made the whole picture come into much sharper focus. Trent hadn't been sitting on that door waiting for me to get sick. He'd already been quietly using a narrower piece of standard signing authority, the kind any co-managing member legitimately has, to redirect a portion of the company's equipment leasing arrangements through a financing brokerage where, it turned out, he sat on an unpaid advisory board, the kind of arrangement that looks perfectly clean on paper and generates a soft, deniable stream of professional goodwill and referral credit that quietly built his own standing at the bank where he worked. Using my company's equipment purchases as the vehicle. Nothing illegal, Elliot confirmed after we reviewed it together. Nothing you could take to a prosecutor. But it told me everything about the kind of man I was dealing with. He wasn't a monster who woke up one day plotting to steal a company from a sick old man. He was a patient, methodical man who had built himself small, deniable advantages for over a year, testing how far the structure would let him go, while quietly positioning a much larger lever, that diminished capacity clause, in case a bigger opportunity ever opened up. I called a meeting with Curtis Bell at the bank privately, the loan officer who'd first flagged the signing authority language to me. I asked him, off the record, whether he was aware Trent worked at the same bank, in a different department, and whether that created any conflict in how these equipment financing applications had been routed. Curtis went quiet on the phone for a moment, the particular quiet of a man realizing he'd stumbled into something larger than a routine paperwork question, and told me he'd need to loop in his compliance team, but that he appreciated me bringing it to him directly instead of letting it sit. I decided, after those 3 weeks of quiet fact-gathering, exactly how I wanted to handle this. Not with a lawsuit, not with a screaming confrontation at a family dinner. I wanted Rebecca to understand fully, in her own time, without feeling ambushed or forced to choose a side in front of an audience, exactly what her husband had built into a document she'd signed trusting him completely. And I wanted Trent to understand, clearly and permanently, that the door he'd built for himself had just been welded shut, without me ever needing to raise my voice to do it. I asked Rebecca to come by the shop alone on a Saturday morning, just the two of us, the way we used to do when she was a teenager, and I'd let her help sweep sawdust after closing so we could talk without her mother or anyone else around. She came, a little confused about why I hadn't just called, but she came. I walked her through it slowly, the same way Elliot had walked it through with me, starting with the equipment financing call from Curtis, moving through the full operating agreement language, ending with the diminished capacity clause and what it would have meant the first time I got seriously sick or simply got old enough that a doctor could reasonably question my sharpness. I didn't editorialize. I didn't tell her what to think about her husband. I just laid out what the document actually said, the same way I'd lay a blueprint flat on a table and let someone read the measurements themselves. I watched my daughter's face change over the course of maybe 20 minutes, the particular kind of change that happens when someone realizes a story they believed completely has a second version underneath it they never got to read. She didn't cry right away. She got very quiet, the way Rebecca has always gotten quiet when she's working something out that's too big to talk through out loud yet. "Dad," she finally said, "he told me this was standard. He told me every family business does this kind of restructuring eventually, and that having a physician sign-off requirement was actually protective, so nobody could just declare you incompetent without a real medical opinion behind it. That's a very convincing way to describe a door that only he controls the key to," I told her, gently as I could manage. "Rebecca, I'm not asking you to hate your husband. I'm asking you to understand what you actually signed, and to decide for yourself, now that you understand it, what you want to do about it." She sat with that for a long time in my shop, surrounded by half-finished staircase spindles and the smell of sawdust that's been part of her whole life, and when she finally spoke again, her voice had the same steady, deliberate quality I'd heard in my own voice 3 weeks earlier, sitting in Elliot's office. "I want to see the whole document myself," she said. "All of it. Not the summary he gave me. And I want to be in the room when you deal with this, Dad. Not because I'm choosing you over him yet. Because I need to hear how he explains this himself, in his own words, before I decide anything." That was exactly the answer I'd hoped for, and exactly the kind of daughter I'd raised, even if I hadn't always been sure of that these last few years watching her orbit further into Trent's world of finance seminars and country club memberships. We arranged the conversation for the following Thursday evening, at my house this time, not Rebecca and Trent's, because I wanted Trent walking into a room that was mine, the same deliberate choice I'd make laying out a difficult joint, working on my own bench, in my own shop, on my own terms. Elliot came, at my request, not as an aggressive presence but simply as a professional who could speak to the document's actual language if questions arose that I couldn't answer with full precision myself. Rebecca arrived first, quiet, resolute, carrying a printed copy of the full operating agreement she'd apparently spent the last several days reading line by line herself. Trent arrived expecting, I believe, some kind of family dinner conversation about the CNC router financing, the same surface-level business chat we'd had a dozen times over the years. He came in relaxed, comfortable, kissed Rebecca on the cheek, shook my hand with that same beak-too-firm grip he'd always had. "Dad, Rebecca, good to see you both, what's going on?" I let him sit down before I said anything. I let him get comfortable, the way I'd let Daniel get comfortable over pot roast in another story I once heard, because there's a particular value in letting a man settle fully into a chair before the floor shifts underneath him. "Trent," I said, "I want to talk about the holding company structure you set up for us 14 months ago. Specifically, I want to talk about the diminished capacity clause on page 31, section 4, subsection C." I watched something flicker behind his eyes, gone almost as fast as it appeared, the particular flicker of a man doing rapid mental math about how much I actually knew. "Sure," he said, his voice even, professional, the voice he probably used with nervous loan applicants every day of his career. "That's a standard protective provision, Harold. It exists to make sure the business can keep operating smoothly if something ever happens to you, without a court guardianship process dragging things out for months." "Protective for whom?" I asked, keeping my own voice level, the way I'd kept it with Preston in another telling, the way steady men keep their voice level when the moment finally arrives to say the true thing out loud. Because as I read it, and as my attorney read it, the only person who gains independent operating authority under that clause is you. Not Rebecca. You. Triggered by a diagnosis from a physician that you and Rebecca, together, get to choose. That's just standard drafting language, Trent said, a little faster now, a little less smooth. Any competent restructuring attorney would tell you the same thing. Elliot spoke up for the first time, quietly, professionally, the way a good attorney does when the moment calls for precision rather than aggression. Mr. Callahan, I've drafted or reviewed probably 200 family business succession documents over my career. I've never once seen a diminished capacity trigger paired with an independent signing threshold that specifically excludes the founder's biological child from the physician selection process while including only the spouse. That's not standard. That's specific. The room went quiet in the particular way rooms go quiet when a carefully constructed story finally runs out of room to keep explaining itself. I turned to Rebecca then, because this next part needed to come from her, not from me. Trent, Rebecca said, and her voice was steadier than I expected, steadier than I think even she expected, I read the whole document this week. All of it. I want you to explain to me, right now, in your own words, why you built a clause that gives you authority over my father's company that I don't have, triggered by a doctor that you get to help choose. I watched my son-in-law search for an answer for a long moment, and I want to be fair in telling you what happened next, because it wasn't a full confession, and it wasn't the kind of dramatic collapse you might expect from a story like this. Trent is too controlled a man for that. What happened instead was quieter, and in some ways more damning. He started to explain, then stopped, then started again with a slightly different explanation, the particular stammering pattern of a man realizing, in real time, that every version of the truth he tries out sounds worse than the last one, because there simply isn't a good version of the truth available to him. I was protecting our future, Trent finally said. Rebecca's future. Our kid someday. I wasn't trying to take anything from your father, Rebecca, I was trying to make sure that whatever happens down the road, we're not left scrambling. We, Rebecca repeated, quietly. Not my dad's company being protected for my dad. We. Our future. You built yourself a door into a business that isn't yours, using my signature, and you're calling it our future. I didn't say much else that evening. I didn't need to. I'd learned a long time ago in negotiations that the person holding the real leverage doesn't need to raise their voice to prove it, they just need to let the facts sit in the room until everyone in it understands the actual shape of what happened. What I did instead was slide a second document across the table, one Elliot and I had prepared over the previous week, once it became clear how this conversation was likely to go. A full dissolution of the holding company structure, reverting Ashcroft Millwork to its original sole proprietorship form under my name alone, with a new, much simpler succession trust established separately, one that named Rebecca as sole eventual heir to the business, with no advisory or contingent authority granted to any spouse, present or future, under any circumstances, ever, full stop. A provision Elliot assured me was about as ironclad as language gets in a family trust document. I'm not doing this to punish you for loving my daughter, I told Trent, and I meant it, the same way Walter meant it telling his own son the estate changes weren't punishment. I'm doing this because a man who builds himself a hidden door into another man's life's work isn't protecting anybody's future. He's just waiting for his moment. And I'd rather you never get one. Trent didn't argue. I think, somewhere underneath the practiced calm, he understood there wasn't an argument left to make. He signed the dissolution paperwork that same evening, because refusing would have meant explaining to Rebecca, in far more detail than he wanted to, exactly why he was so reluctant to give up authority he'd claimed all along was purely protective. The marriage didn't end that night, and I want to be honest with you about that too, because I know some of you watching might expect a cleaner, more dramatic ending, a divorce filed on the spot, a door slammed, a suitcase on a porch. That's not what happened, and I think that's actually the more honest version of how these things go in real families. Rebecca needed time, real time, to decide what this revealed about her marriage more broadly, separate from what it meant for my business. They went to counseling. I don't know everything that happened in those sessions, and I've deliberately not asked, because that part isn't mine to know or to tell. What I can tell you is that 6 months later, Rebecca came by the shop again, alone, on another Saturday morning, and told me she and Trent had separated, not because of the holding company specifically, she said, but because once she started really looking at their marriage with the same clear eyes she'd used reading that operating agreement, she found other doors he'd quietly built for himself in other corners of their life together, smaller ones, financial and otherwise, that she'd simply never thought to look for before. I run Ashcroft Millwork alone again now, the way I did for most of my 39 years, except Rebecca comes by the shop most Saturdays, learning the business properly this time, from the ground up, the way I probably should have insisted on years ago instead of letting a holding company document try to shortcut something that only actually transfers through years of showing up and learning the grain of the wood yourself. I think about that diminished capacity clause sometimes, late in the evening after the shop's gone quiet, and I think about how close I came to never finding it at all, how easily a bad reaction to anesthesia or a bout of pneumonia could have quietly handed my life's work to a man who'd spent a year and a half building himself a door nobody else knew existed. I don't feel triumphant thinking about it. I feel something closer to grateful, the particular gratitude of a man who checked a joint one more time than he needed to and found the crack before the whole structure gave way under weight it was never built to hold. Rebecca asked me once, a few months after all of it settled, why I hadn't simply exploded at Trent the moment I found out, why I'd spent 3 quiet weeks gathering facts instead of confronting him the same day. Because anger tells you how you feel, I told her. It doesn't tell you what's true. I needed to know what was true first. The feelings could wait their turn. She's building something of her own now too, alongside learning the shop, a small side business restoring antique hardware for the same kind of historic homes we do millwork for, the kind of quiet, patient work that runs in this family whether anybody planned it that way or not. I watch her some Saturday mornings, hunched over a workbench with a piece of hardware from a house built before either of us existed, and I think about the fact that the thing Trent tried to build a door into wasn't really a company at all. It was this. A daughter learning, slowly and honestly, the actual shape of the thing her family built, one grain at a time, with nobody else's hand quietly guiding the blade. If you enjoyed this story, join our community by hitting that like button and subscribing for more real, raw, and family-centered stories. And as always, thank you for being a part of Revenge Confirmed.